appeal in the matter of Mackenzie and AA and another part heard.
Good morning, Mr. Laddie.
Morning.
I'll just ask Lord Justice Popplewell to say good morning or something to make sure that he can hear us and we can hear him.
I can hear you.
Good. Thank you. We can hear you. Yes, Mr. Laddie.
Good morning, my lord. Can I just say on behalf, I hope, of all parties, we're very grateful that the court's been able to relist this appeal during the course of this term.
We're grateful to both of you, including Mr. Mansfield, who had to make all sorts of arrangements to be here, but that's good.
It's either Concord or the Hoover.
Right.
I'm impressed that my lord's narrowed it down to those two.
All right, well,
Extremely acute
hope for the best.
hearing.
Press on.
The first day of this appeal was recent enough that I hope I needn't revisit any of the submissions that have already been made. So if I may, I'm just going to take it up to from where I left off.
Yes.
Last time, and my lords may recall that the position that we were adopting at the close of day one was that there was effectively a rule of law in wrongful dismissal cases that the least burdensome principle demanded that the question for the court should be when was the earliest available date of dismissal, and that provided the answer to claims for wrongful dismissal. And that met with, if I may say, some surprise and resistance from the court, and in the longer than expected intervening period, we've had an opportunity to rethink our position in relation to that. There are many authorities, I'll identify them in a moment, which state that in a case of wrongful dismissal, the question for the court is when was the earliest date on which the employer could lawfully have dismissed. But we accept upon reflection that hasn't created an independent, freestanding rule of law. It's simply an illustration of the operation of the least burdensome principle in practice. As it happens, we struggle to conceive of a wrongful dismissal claim where the least burdensome principle wouldn't result in simply asking when was the earliest date on which dismissal could have occurred. But we needn't go so far as we did on the last occasion and try and elevate that into a rule of law. In any event, in this case, the position is, we say as follows. Least burdensome means the cheapest. These all claims for breach of contract effectively are, certainly wrongful dismissal claims, are claims for damages, so one's primarily concerned with financial balance. And in employment cases, cheapest is typically synonymous with the earliest possible dismissal. The earlier the employer dismisses, the fewer financial obligations he is likely to owe to the dismissed employee. So we ask ourselves the following question: when would it be permissible in an employment case, a wrongful dismissal case, to conclude that least burdensome did not involve the earliest possible dismissal? And there are two possibilities that we have been able to identify. First, if on the maths, the earliest date of dismissal was not the cheapest. And this should be evident on the face of the contract. We're concerned, of course, here with contractual obligations. Look at the terms of the contract. If, through some quirk of the contract, it was more expensive to dismiss earlier than it would be to dismiss later, then we accept that the least burdensome principle would not result in the earliest possible dismissal. That's not this case, of course. Second, and this is of perhaps more importance, given my learned friend's submissions, if for some other reason the earliest possible dismissal involved cutting off one's nose to spite one's face, In other words, some form of industrial self-sabotage. There is only one case that we are aware of where this principle has been engaged in practice, and that's the case of Bold and Brough Nicholson. It's in the bundle of authorities at tab 4.
Well, you probably don't need to take us to it, Mr. Laddie, and it's a famous case. I remember being taught at law school half a century ago about the contrast between that case and Laverack. But in that case, in order to bring the individual contract entitlement to an enhanced pension or something to an end, the employers would have had to wind up the whole scheme.
That's right.
And that is not this case.
It's absolutely not this case. The language used by Mr. Justice Phillimore in that case was, he asked rhetorically, would the employer have done something so disastrous to industrial relations simply to defeat a claim by this plaintiff? Our answer obviously no. It absolutely is not this case. So whilst no doubt in Bold there was the contractual right on the part of the employer to simply withdraw the scheme, the employer could only do so by withdrawing it from the entire workforce. Plainly, that's not the position. We are miles away from that in this case. Here, we're concerned simply with the exercise of a clause which we say, first of all, is a commonplace clause in contracts of all types, but the point is it's a clause that was agreed, the pylon clause was agreed between the employer and the employee in this case, designed precisely to cater for this sort of situation.
You may be coming on to this, but speaking entirely for myself, I was in much the same position as your revised position today. And it raises the question, if the foundation is that the law of damages for breach of contract is essentially compensatory, and if one accepts that probably, or in most cases, typically I think is the word you used, the earliest date of lawful termination is going to provide you with the right answer, where does the burden of shifting from that position lie? My instinctive reaction is that there's at least an evidential burden upon a claimant then to demonstrate that the earliest date of lawful termination is not the appropriate measure.
I'm not going to pretend, my lord, that I've thought this through, but my instinctive position would be the same. That since there is effectively a presumption, I'm not going to put it higher than that, the full position is, as I say it is, cheapest equals least burdensome. If a party wishes to depart from the presumption or persuade the court that it doesn't apply in the circumstances of the particular case, it should be the party asserting that it doesn't apply, which will inevitably be the claimant.
But that's likely to be evidential rather than a rule of law or
Yes,
anything
I agree.
like that.
I agree.
An evidential burden.
Yes.
Yes. Thank you.
So that, in short form, is the position of principle that we adopt after reflection. Can I now turn to the facts of this case? Obviously, I'm still in the context of ground one. The starting point is simply to compare the cash positions for the AA, comparing the cash positions upon exercise of the pylon, and if on claimant's case, the alternative position, which is non-exercise of the pylon, giving 12 months' notice. On the claimant's case, indeed, this is what the claimant is claiming, there is a difference of approximately £1 million.
You did this last time,
Forgive me.
I think.
I think I set out what the differences were.
Pension contributions, car, medical
Exactly.
insurance, PHI, and full bonus.
All I'm doing now is I'm applying the principle so one can see the difference. So the presumption, if that's the right way of putting it, applies perfectly in this case. You say this is a case where plainly it is much cheaper in financial terms to dismiss as early as possible. under the pylon. Say no more about that. That's a vast difference between the two positions. So I now turn then to the claimant's real position on this appeal, which is that this is effectively a cutting one's nose off to spite one's face type of case. And Mr Mansfield, as I understood it, relied on two arguments in support of his proposition, in support of his appeal. First, the share price point. Second, what he described as the smoothness of transition. And I'll deal with those in order. His position on the share price, as I understood it, was as follows. The consequence of dismissing under a pylon would be so prejudicial to the share price that it would amount to cutting off the AA's nose to spite its face. And he supported this argument by reference to what he said was the actual impact upon the AA's share price of his client's dismissal, summary dismissal for gross misconduct on the 1st of August 2017. I don't accept the factual premise in any event. That's to say that there was a very significant impact on the share price via Mr Mackenzie's dismissal. But it doesn't matter, because my learned friend's reliance on the share price as it was in fact impacted on the 1st of August 2017 is with respect to misconceived. The proper comparison here is the difference between the impact on the share price of a dismissal under the pylon or a dismissal upon notice. We're here in the realm of the counterfactual. We are not concerned with what in fact happened. Either type of dismissal would have to be announced to the market. This is, of course, a listed company. There is no basis at all for supposing that the market would draw any substantial or significant distinction at all between the dismissal of Mr Mackenzie on notice and the dismissal under a pylon.
Was the suspension and the reason for the suspension announced to the market?
I don't believe so. It all happened very quickly within a period of 5 or so days,
Yes.
as you may recall. I don't believe so. Whether it ought to have been or not.
Because there were quite a lot of announcements in the week, in the sort of critical week and 10 days, either running up to dismissal or just after. And I've just got a nasty niggling feeling that something was said which implied that there had been a problem rather than just a dismissal.
My Lord, the announcement upon dismissal made it clear that the dismissal was not related to financial misconduct. I don't know if that's what my Lord is thinking about. Our recollection is that there was no pre-dismissal announcement. If I'm wrong, I see Mr Mansfield.
If a director of a listed company resigns, there's an obligation to announce that to the market immediately, isn't there?
Yes, and I don't think that obligation wouldn't have been breached, because the resignation took, Mr Mackenzie's resignation was on the afternoon of the 31st of July, and the dismissal, in fact, the decision to dismiss was taken on the same day and was announced the following day to the market. So, I don't think there's anything amiss about the way that the AA treated that.
Yeah.
I don't know. I'm not pretending to know whether or not the suspension ought to have been announced to the market, that was on the 26th of July. It wasn't, as far as I know. That's, I'm afraid, is the simple fact of the matter. But of course, it isn't just our case that Mr Mansfield's argument that this is cutting off one's nose to spite one's face is not justified. In fact, the opposite is the position. The board would have been pilloried both internally and externally, as soon as it had emerged that it had, this is on Mr Mansfield's case, that it had volunteered to accept the obligation of keeping Mr Mackenzie in employment at significant financial cost to the AA, in circumstances where the AA could have used the pylon clause. Of course, as a director, Mr Mackenzie's terms and conditions of employment were open to inspection by members of the company under Section 228 of the Companies Act. The expectation, given the circumstances leading up to the dismissal, would have been that the dismissal would have been effected in as swift and cheap a way as possible. I don't say anything more about the share price point in our submission. That argument goes nowhere. Second, in oral submissions, Mr Mansfield argued that it would have enabled a smoother transition had Mr Mackenzie been dismissed on notice. With respect, I didn't quite follow the argument here. What actually happened was that Mr Mackenzie was dismissed. Mr Breakwell took over. That was the transition. It involved one change. What I understood Mr Mansfield to be arguing was that it would somehow be smoother for the AA to have put Mr Breakwell in charge on a temporary basis, pending Mr Mackenzie's recovery at some point after 6 months sick leave. Mr Mackenzie would then return for a few months to serve out his notice at work, and then someone else, presumably Mr Breakwell, would take over permanently. That is the antithesis, we submit, of a smooth transition. Those were the 2 points that we relied on in support of his global case, that the employer's exercise of the pylon clause in this case would be an exercise in cutting off its nose to spite its face.
Forgive me for interrupting. Does his resignation have any impact on this?
On this point?
Yes.
Not in support of Mr Mansfield's case. Let me put it that way. The resignation only assists us. We say that at trial, we would be able to contend that it would in fact be cheaper to go outside the terms of the contract itself and take advantage of what at that stage was, Mr Mackenzie had resigned, but my lords will recall that he offered to resign with immediate effect. That would in fact have saved the £750,000 that the AA would have been obliged to pay under the pylon. That didn't form part of our application for strikeout, but we reserved the right to argue that at trial.
And that course of action would bring the good or bad leaver clauses into play, wouldn't it?
I'm not sure, given the way that the case has now been presented, that the good or bad leaver clauses really have any particular impact anymore. Mr Mansfield's case, as I understand it, is dependent upon showing that his client was wrongfully dismissed.
You're talking about, when you were speaking about the claimant offering his resignation, that's his resignation from employment.
Yes.
But as my Lord Justice Popplewell pointed out last time, in fact he resigned unconditionally from his directorship. Indeed he did.
Of course, the wrongful dismissal claim is a claim based upon his status as an employee rather than his status as a director.
Yes.
It is perhaps more significant. I'll touch on this point when we come to look at ground 2 in just a moment. But for the purposes of the wrongful dismissal claim, I'm not sure that I can contend that his unilateral and effective resignation as a director is of any particular significance in terms of the contractual analysis, much though I would like to do so.
Well, I wondered whether it is a further stumbling block in the path of Mr Mansfield's smoother transition argument.
Because of course he would have to somehow unravel his earlier resignation. I hadn't thought about that. It doesn't help the smooth transition point. Let me put it that way. If one looks at what in practice would have to occur in order for Mr Mackenzie to somehow play an effective role in the business in the second 6 months, assuming, of course, his recovery in the intervening period. It is, as my Lord rightly says, another stumbling block. Thank you. That concludes our submissions in relation to ground one. We say this is a completely straightforward case. In fact, it's a strikingly clear case for application of the least burdensome rule with only one answer. The idea that the least burdensome option was to pay approximately £1 million to this employee effectively as a gratuity and risk opprobrium from all quarters is, with respect, certainly unsustainable. One could hardly imagine a more compelling case to justify the exercise of the pilot. And we simply do not understand the contention that it's necessary for this matter to be sent to trial in order to resolve it. To have director after director step forward and explain their thinking, explain why the case advanced by Mr Mansfield does not involve a smoother transition. And what about expert evidence upon the possible impact of the different modes of dismissal upon the share price? Again, Bold and Brough Nicholson is authority for the proposition this not cutting off one's nose to spite one's face principle. But it will only be in a rare and very clear case where that argument is available to a claimant. This is not such a case, quite the contrary. My Lords, unless I can assist further in relation to ground one, can I turn now to ground two? This is the claim for the MVP shares. When on his feet, my learned friend conceded that ground of appeal is contingent upon the success of ground one.
Yes.
And it is crucial for us to remind the court that the case was argued in a quite different way below. It is now presented, the claim for the MVP shares, as an aspect of the claim for wrongful dismissal. It's a pure contractual claim. I accept that that is an argument that's available to Mr Mansfield on his pleadings, but before the Deputy High Court judge, the case was in fact argued in a quite different way. My Lords will recall there was a personal injury claim.
Yes.
And without going, there's no appeal against the decision to strike out or give summary judgment on that claim. But it's important to recognise the way the MVP shares claim was argued below. Mr Mansfield's case started from the premise that the personal injury claim would succeed. Obviously, history proved him wrong in that regard, but that's the premise, the starting point. His case was the AA caused his client personal injury. Had it complied with its obligations to Mr Mackenzie, Mr Mackenzie would not have become ill. He would not have assaulted a subordinate employee. He would not have been dismissed. He would have remained a fit, healthy man, etc., etc. And if that was the case, that was actually on which summary judgment was given. The case now before the court is much more difficult for Mr Mansfield. Not only does he have to succeed on the wrongful dismissal claim, he also has to show that there was a realistic chance of him in fact returning to work. We're no longer talking here about being on the payroll. We're talking about him returning to work. His case is he would have been able to return to work and influence in a positive way the share price. He also has to show that if he returned to work, there was a realistic chance of him being able to influence the share price so that it met the necessary contractual threshold in either 2018 or 2019. So let me deal with those stages. Point one, obviously, our primary position is he loses on ground one and the rest of it becomes immaterial.
Yeah.
But even if Mr Mansfield wins on ground two, it is in our submission utterly fanciful to suppose that there was any prospect of Mr Mackenzie returning to work. There are two aspects to this. First, Mr Mackenzie's own position. This itself involves two sub-points. The first is the unilateral resignation as a director point. The second is Mr Mackenzie's own state of health. In the supplementary bundle, at page 279, I believe we looked at this.
Do you want to do it?
Yes, please.
Yes, we did.
It's page 279, please, my lord. At page 279, we have a medical report produced on the 31st of July by a consultant clinical psychologist. Forgive me, I can't recall whether we looked at this last time. We did. My lords will remember.
Sorry, it's not in my supplementary bundle at 279.
It's the next page, I think.
280 is the resignation letter.
Is it the page before?
Can I just see 279?
I'm so sorry, I'm not sure why that isn't in my lord's bundle.
I'm sure it's my fault, not yours. So let me just read it. Thank you.
So, what we have here is a recommendation Mr Mackenzie be released from all work duties for a period of approximately 6 months. A total break from work demands for approximately 6 months. So Mr Mansfield's best case is that at the end of 6 months, Mr Mackenzie has made a complete recovery and he returns to work on a full-time basis. Of course, that's not the way the world works. Somebody who's been so ill that they have to take a 6-month break from work, in my experience, doesn't tend to return to work on a full-time basis. It's a phased return at best. And of course, 6 months is a prediction, no more than that. And this is where the Golden Strait case, which Mr Mansfield relied on in support of his attack on the Laverack principle, comes into effect in a perfectly different way. In fact, Mr Mackenzie did not recover within 6 months. Our understanding is Mr Mackenzie has never recovered. Can I take my lords to the psychiatric report that he relied on for the purposes of his claim? That's also in the supplemental bundle. It's dated, I think, July 2019. It's at page 3. It starts at page 347.
Professor Ismail.
Yes. And we only have extracts of it. It's dated the 21st of July 2019. Could my lords turn within that report to page 353, please? Sure. Mr Mansfield's asked me to make clear we've had the full report. Yes, we have had the full report.
Yes.
We didn't think to trouble you with it, but of course a full copy can be made available if the court wishes.
Just the way you phrased it, we've only had it.
Oh, I didn't mean to say that. I didn't mean to suggest that we've only had extracts of the report. We only have extracts of the report in the bundle. I should make that clear. If one takes psychiatric history, I hope the court will understand why I'm not going to read this out.
Yeah. We can read it to ourselves. How far should we get?
Could you read the whole of psychiatric history on that page? And the next page, could you read the first 2 sentences of the final paragraph? Sorry, first 3 sentences of the final paragraph on page 354.
This is almost exactly 2 years on.
My lords can delve into the rest of that report as one wishes, but one can see is that the man who is examined by Professor Ismail in July 2019, long after the expiry of the notional notice period in this case,
Is not fit to work.
not fit to work. And the Golden Straits case, which we have at tab 20 of the bundle of authorities, is authority for the, I'll wait for my lords to get that up. We only need to go to the head note for this. This is a charter party claim where the charter party was breached, or repudiated I should say, and then war broke out. And the question of what, from a damages perspective, the effect of an intervening war, which had necessarily broken out, should have on the claim. If we take it from the head notes.
Sorry, Mr. Laddie, can I just catch up? Tab 18.
Tab 20 of the bundle of authorities. I'll read out, dismissing the appeal. The principle, this is, I should say, a 3-2 majority in court. The principle that damages should be assessed as at the date of breach was not inflexible. The desirability of achieving certainty in commercial contracts was subject to the overriding compensatory principle that the damages awarded should represent no more than the value of the contractual benefits of which the claimant had been deprived. That if at the date of breach there had been a real possibility that an event would happen terminating the contract or otherwise reducing those contractual benefits, the quantum of damages might need to be reduced proportionately to reflect the estimated likelihood of that possibility materialising. But then this, but that where such an event had already happened by the time damages were assessed, the court should have regard to what had actually occurred, so that estimation was no longer necessary. In other words, we know, assuming for the sake of argument that the date of assessment of damages is today, that in fact Mr Mackenzie has never recovered. He would never have been able to return to work, and thus on the Golden Straits principle, one has to operate on the basis that he could not have returned to work, and thus could not have had any positive impact upon the share price.
Is there either in this case or ever, a distinction to be drawn between circumstances which are extraneous, as in Golden Straits, and circumstances which are intrinsic to a party? I suppose health probably wouldn't fall, as it were.
It's not easily defined. It's not easily categorised.
It's not easily categorised, but a person's health, I can see one can put into the same bracket as what's being spoken about here. I suspect there may be other circumstances. If for example, a claimant behaves in a certain way to defend, to mitigate his losses or whatever,
yes,
then this might need a bit of qualification.
Indeed, because that would be a response to a particular set of events which would not necessarily have occurred had the contractual breach not taken place. But we're not in the same territory, because now that the personal injury claim has gone, Mr Mackenzie's state of health, I'm afraid, simply stands as a historical fact, and he did not recover over the period during which he now claims, had he been given notice, he would have returned to work. The reality is he would not have done. That's what history tells us. So that's the claimant's own position. Second, the AA's position. Again, this is in the context of the appellant's case, that he would have returned to work and influenced the share price in a positive way. The AA had moved on. They had put Mr Breakwell in charge. And this wasn't a knee-jerk response to an event which they obviously hadn't predicted, the assault on the subordinate employee. All it was an accelerated transition of a kind that had been in the pipeline for a couple of years. And my lords will recall the judge below referring to the fact that the AA's public documentation made it clear that they were expecting to move Mr Mackenzie into the role of non-executive chairman in any event. So all that happened was this, and that's to say he'd be replaced in an executive role. Obviously he didn't move into the non-exec chairman role, but he was replaced. The idea that the AA, even if Mr Mackenzie had been fit enough to return to work, would have been parachuted back into an executive position is, with respect, utterly fanciful. And then finally, even if we're wrong about that, Mr Mackenzie has to persuade the court that there was a realistic prospect of him returning to work and getting the share price to the requisite level. I appreciate the court will have seen the numbers or the figures in the judgment below, but it is worth just restating. On the date of the first assessment for the purposes of the MVP shares, that's 24th of June 2017, whilst Mr Mackenzie was still in post, the required share price was £3.52. That's what the share price needed to be for the MVP shares to hit their target. The actual share price was £2.20. 1 year later...
Sorry, what was the date of that?
24th of June 2017. One year later, so this is after Mr Mackenzie's dismissal, the required share price was £3.93. The actual share price was £1.32. And the year after that, the required share price was £4.40, the actual share price 48 pence. So just in simple mathematical terms, this is what Mr Mackenzie has to persuade the court that if he had returned to work in the narrow 6-month window after his 6-month convalescence and been permitted to exercise an executive function, he would have had such a transformative effect that the share price in the first effective year would have multiplied by a factor of 3, or at least there was a realistic chance of it doing so. And in the second year, after his departure, it would have multiplied by a factor of 9. That is something which is completely out of the bounds of probability for any executive. Lest it be thought that we're unfairly targeting Mr Mackenzie. That's a miracle. That's not a realistic assessment of any individual executive's capabilities. But I'm afraid.
I think slightly more technically, you're saying that the judge below was entitled to conclude without it having to go to a trial that was not going to happen.
He was entitled to conclude, and he was correct so to conclude.
Because that's the question for us, isn't it?
Yes.
Sorry to be pedantic.
Not at all. Thank you for bringing me back to the straight and narrow. Absolutely, he was entitled so to conclude, but the evidence was overwhelming. That was the only proper conclusion to reach. It's also, there was a whole host of additional supplementary reasons that we relied on. But can I just draw attention to two, if I may? The claimant himself had presided over a sustained decline in the share price and had sought a deferral to the MVP scheme. And he corresponded with the AA's brokers in respect of this. Could I ask my lords to take the supplementary bundle at page 223? No, sorry, I've got the wrong page. Sorry, 242, I beg your pardon.
242.
242, I'm so sorry. So this is in 2017, the same year as the dismissal. And what one can see at 242 is an email from one Bob Morris of Senkos. So Senkos were AA's brokers. And the context for this is that Mr Mackenzie and Martin Clark, the CFO, were floating with Mr Morris the possibility of going to the principal investors and asking them to defer the stages of the MVP to give the management team more of a chance to hit the target price. And this is Mr Morris's response. I invite the court to read the whole thing, but perhaps the most vivid passage lies in the fourth paragraph. I think the approach regarding your proposal is actually quite straightforward. The questions that need to be answered are there extenuating circumstances, and are you being rewarded for failure? Now, in a sense, it doesn't really matter whether there are extenuating circumstances or the management team were seeking to be rewarded for failure. The real point here is that Mr Mackenzie was recognising in 2017 that even at that stage, just before the assault, before the unmasking of his illness, etc., it was already clear to him and Mr Clark that it was unlikely that the target price would be met. That's the first point. The second point is that Mr Clark himself, essentially Mr Mackenzie's right-hand man, wrote a memo at page 264 of the same bundle He wrote this in April 2017, where he describes the AA as an existential crisis in the making. It's quite a long document.
Could you just give us the date again?
It's April 2017. I'm sure I can give you the precise date in just a moment. 8th of April, my lord. Where Mr. Clark sets out a series of problems facing the AA, hence the title An Existential Crisis in the Making. They include, at page 266, under management, the heading management, what he describes as the nub of the matter. And at paragraphs 2, 3 and 4, under that section, he sets out his thoughts upon Mr. Mackenzie and then at 267, at the foot of the page, in terms of steps required, says we need a new chief executive and we need that appointment now. He said it was too late to start the process in the following financial year. Bob should become chairman, the outside world should see it as a seamless transition and an elegant resolution to the promised management succession.
Where are you?
ARA.
Got it.
Vague promise in the ARA.
I think it's the annual resolution.
Annual report and account.
Yes, annual report and accounts. That must be what it is. Thank you. It's something that is referred to by the Deputy High Court judge below. That's to say, that's where there was a published statement of intent to transition from Mr. Mackenzie in the dual role which he held up to the point of his up to the 31st of July to a backseat role. And can I just very briefly deal with Mr. Mansfield's point that there were whispers of a bid in spring 2017. I think the point was made whilst he was on his feet that ultimately there was no such bid. But we would add, it doesn't matter even if there had been a bid in spring 2017. What we are concerned about is whether or not Mr. Mackenzie, had he been given 12 months' notice, would have been able to positively affect the share price in 2018 and 2019. The world moves on. Anyway, as it happens, there was no bid, nothing more than a rumour. So the difficulties facing the appellant are enormous. This even on the supposition that he succeeds in relation to his ground one. The last point I wish to make in relation to this ground of appeal, and indeed the appeal in general, is just to address the criticism which is laid at the judge's door that he was wrong to draw attention to the impossibility of applying this issue. As I understand Mr. Mackenzie's case, it's not to say that he would have positively influenced the share price to the requisite level. I think that there is belatedly a recognition that that is not really a tenable proposition, but there's a chance that he would have done. So how would this case be tried? There would have to be something like a state trial into the workings of the AA, both as it was and as it would have been, and how it would have been received by the market, had decisions X, Y and Z been taken by Mr. Mackenzie rather than decisions that were in fact taken by Mr. Breakwell. That would be unworkable. It would be lengthy, expensive, but most of all, in our submission, a colossal waste of time.
But I don't actually understand what you're saying. If you're saying it's unworkable, it could be done. You could have a trial. It'd be very expensive. But what does this add to your submission that there's no basis for having a trial? I mean, it's safe to say that if you did have a trial, it'd be very expensive.
It's more than just the sheer expense of it. It's a trial about hypotheticals. I appreciate that also sometimes occurs. It was relied upon by us below and indeed by the judge as an additional reason, a supplementary reason for reaching the view that this is a case which, in respect of which, a strikeout or summary judgment should be ordered, I should say. I'm not going to push the point beyond that. The reality is, even before you get to the question of how feasible a trial would be, the legal and factual basis upon which this claim is presented is unsustainable. And therefore, the judge was right to strike out.
You have to show that it's clear that the claim had no reasonable prospect of success. The more complicated it is, the less attractive that argument becomes. But perhaps if one never gets to that, then it doesn't matter.
Indeed, and we were keen and remain keen to argue that at its heart, this is actually not a very complicated case. The essential elements that Mr. Mackenzie has to prove are quite straightforward. Wrongful dismissal, would have returned to work, would have been able to positively influence the share price. The evidence against any of those individual events being proved is so monumental that we needn't actually get into the weeds of what the trial might ultimately look like if it was to be allowed to proceed to that stage. I've taken a little longer than I said I would, and more than I anticipated. But unless I can assist further, those are our submissions.
Thank you very much. Mr. Mansfield.
My Lord, might we be permitted a short break before I
Yes.
reply? I anticipate being very brief in reply.
Yes, that's fine.
Before your Lordship
Mr.
rises,
Jackson can tell you what to say and what not to say.
Indeed, my Lord. Before your Lordship rises, can I just draw to your attention two authorities that were sent to the court last week that we had given to Mr. Laddie and Mr. Smith
right.
on the morning of what was to have been the second day of the hearing. I think they've
Just
been...
tell us what they are and we'll see whether we've got them.
One of them is Cerberus and Rowley, and the other is a case called Sheffield and Oxford Controls. I think they were lodged electronically. I'm told by Miss Jackson they were. But I have hard copies if that would
yes, please.
short circuit matters.
Speaking for myself.
I got an updated electronic bundle of authorities, but my enthusiasm wasn't sufficient to find out what was in it.
Indeed, my Lord, which is why I thought I might identify what was in it before your Lordship read. I can take the points quite... There should be two of...
Well, my Lord Justice Popplewell doesn't have the advantage of a hard copy.
No, I see that. I wonder whether His Lordship has the revised electronic version or...
Could... does someone have...
I have the bundle. I'm just checking whether the new authorities are in it. If they're not, don't worry. I'll get my hands on them if you give me the citations now.
So Cerberus Software and Rowley, 2001, ICR 376. Sheffield, person's name, Sheffield and Oxford Controls, 1979, IRLR 133.
Thank you.
Should we read them outside?
All right, we'll read them outside while you're taking instructions, Mr. Mansfield.
Okay.
Shall we resume at 11:35?
Okay. gauge as a case that you and I both had similar cases many years ago about discrimination.
The ICI station.
Yeah. Anyway, can I come back to that?
Yeah. Let's talk about it now.
Will rise.
Sorry, it took a little longer than I had predicted to read the cases, but we have now read them.
We haven't got answers.
Sorry, to get to my feet.
Oh, yes, we have a...
Yes, we have.
Right.
I know my lords weren't expecting to hear from me again at all. I neglected. I said I was going to just refer to some authorities. I'm not going to take my lords to them. I just list them. The authorities which stated that the earliest lawful termination is typically the basis upon which damages will be awarded in wrongful dismissal cases. I'll just list them. They are Gunton at tab 6, Janshuk at tab 10, and Smith and Trafford at tab 28. They span some 40 years of jurisprudence.
Right, Gunton, tab
6, that's the Court of Appeal.
Yes.
Janshuk, that's the President of the Employment Appeal Tribunal, Mr Justice Morrison, that's tab 10. And Smith and Trafford, that's Mr Justice Briggs, as he then was, tab 28. I'm so sorry for getting to my feet again, but forgive me, I neglected to list those as I said I would. And I thank Mr Mansfield as well.
Yes. Mr Mansfield.
I'll go for my lord. My lord, can I deal first of all with that question of whether or not the principle requires one to assume an earliest date of termination? And we had produced overnight after the last hearing Cerberus, which we'd given to my learned friends, having heard the way he put his case then, to elevate the notion that one takes the earliest date of termination as principle of law. Of course, Mr Laddie slightly reformulated his position this morning in relation to that. I think it was my Lord Justice Popplewell who'd asked a question as to whether there are any cases which dealt with the choice between payment in lieu of notice and termination on notice, to which the answer is effectively no, in the sense of looking at that choice as a question of assessment of damages. But Cerberus gives rise to the same context, because, and I'll take it briefly in the light of the way my learned friend puts it now, that was a case in which there'd been a wrongful summary termination. The contract had given a power to the employer to give notice and a power to make a payment in lieu of notice. And you will have seen in that case that the former employee's argument was that they were entitled to a payment in lieu of notice as a debt, effectively, rather than a claim for damages in respect of which there had to be mitigation. And in that case, the employer wasn't saying, well, you've got to assume that the pylon would have been exercised because that's the earliest date of termination. It didn't suit them to say that. So Cerberus really just illustrates the fact that it's a fact-sensitive question as to which route the employer would have gone down as to exercising notice or giving notice or exercising the pylon clause.
There's another way of looking at it, which is if the employee who's been dismissed insists upon the pylon clause, that's inconsistent with alleging wrongful dismissal. If he insists as his primary position, because that's what happened here. It happened in the context of a claim for wrongful dismissal. And at the same time, he was saying, but I'm entitled to something which only comes into effect if my dismissal is not wrongful, because it was a contractual entitlement to terminate on those terms. Or have I completely misunderstood?
Well, I think he was saying that in assessing his entitlement on termination, he was entitled as a matter of contract to a payment of the pylon.
Yes.
And as I understand the case,
that what comes out of Lord Justice Ward's judgment, which is the only one I've read so far, is that there's an inconsistency there, which is why you can't do both.
well, my understanding of the case was it turned on the determination that the employer had the option to make the pylon, but the employee didn't have the right to insist upon its payments.
Contrast Abraham's and Performing Rights Society, which is referred to in this one, was a very unusual contract, which said that if the the contractual arrangement was such that payment of salary in lieu of notice on summary termination was expressly provided for. If the contract says, in the event of Mr. X's employment being summarily terminated, the company must make a payment of 6 months' salary, lieu of notice, then it's recoverable as a debt. But if not, then in the more standard case, like Cerberus, if the employer wrongfully, summarily terminates, the employee probably has a slam dunk case on liability for a basic award in the tribunal, but in the county court or high court, the employee has a claim for damages for wrongful dismissal if in fact he gets a new job within the 6 months, same or a better rate, then that mitigates the damage, doesn't it?
Yes, my lord.
Yes.
Yes.
Okay.
But the effect of what I had understood Mr. Laddie to be saying, although I think this morning he's not saying it, is that as a principle of law, one has to look at the route that gives the earliest date of termination, and that wasn't the approach that was taken in Cerberus.
No.
But it may be I don't need trouble with.
Well, he was right. He was right to retreat from that position, because I think the way he puts it now is that this is simply a subdivision of the general rule, which goes back to the 1840s, and that usually in an employment case, earliest equals less burdensome, but there's no special rule that earliest must be less burdensome.
Yes. And I say that formulation as to usually what happens in a usual case and what happens in another case is really a question of assessment of the facts on a particular case, and that the judge was wrong, the learned judge was wrong in this case to treat the matter as resolved by application of the rule of law, and ought to have put the matter through its trial for its determination as to the facts, as to the prospects of what would have happened had the employer terminated lawfully and not unlawfully. Just before I leave that point, just picking up on the examples that the cases that my learned friend listed just a moment ago, Gunton and the like, which do use the language of earliest.
Whatever next. Do you want us to look at Gunton?
No, so I paused because I thought your lordship was making a note, and I didn't want to forget you whilst you were noting.
I thought you were pausing because of the low-flying aircraft, but no, carry on.
I'm not tall enough to see your lordship's pen, but I was thought you were writing. No, I don't want you to turn those up, my lord, but I just want to make this point, that in the cases that do refer to earliest termination, they tend to do so in a rather different context, and certainly not in this context of a choice between notice or pylon. Say, for example, the well-known case of Gunton was about an employer's failure to carry out a contractual disciplinary process before giving notice to terminate. So in that case, the references to earliest, one can see in the question the court asked itself is how long would it have taken to have gone through the contractual disciplinary processes and then given notice to terminate. So it was a rather different context. The next point, my lord, relates to bold and the cut off the nose to spite the face principle. And my learned friend is right that the facts in bold are quite extreme. But what they illustrate is, as was recognised in Laverack itself, that the determination of the appropriate measure of damages can turn on matters extraneous to the contract itself, including what the employer would have done if they behaved in a lawful manner. And once one accepts in principle that the assessment of damages can turn on such extraneous factors, there are 2 points that I say flow from that. First, well, that's a factual question, a factual assessment, at least of the hypothetical of what would have happened. And second, what's the limit on that factual assessment well, one doesn't get anything from bold that tells one that. One can't have a rule that says, well, the cut off the nose to spite your face principle only applies in the extreme circumstances of facts like bold, because there's no limiting factor to that. One can't say, well, the cut off your nose to spite your face principle only applies in an extreme case. It's just a question of factual assessment in any case as to what the employer would have done, whether the court finds a particular outcome would have been cutting off the nose or not cutting off the nose.
Is it really doing more than saying you're not going to do something which is daft to do?
Well, that's another way of putting it, my lord, yes.
I mean, noses and faces don't really add much.
No.
It's useful.
I accept that. I'm not tied to the language. I'm just using that as shorthand because that's the language that was used. But what's daft to do, to use your lordship's formulation, needs some careful consideration of the facts in a particular case. If I can then turn to the second case that I handed up, which is the Sheffield and Oxford Controls case, which is relevant to some points I just wanted to make briefly in relation to the resignation letters, i.e. the offered resignation from employment and the resignation as director. And my lord, you may recall that in answer to a question from yourself, my lord, Lord Justice Bean, I had referred to the resign or be dismissed line of authorities. And I've handed up Sheffield because that's the case I had in mind. It's an instance that demonstrates what I say is a well-established principle, that if an employee resigns in circumstances where it's been made clear that they will be dismissed, then that counts as a dismissal, not as a unilateral resignation. And we say, on the facts that is pertinent here, by the time of those resignation letters, and this is our pleaded position, it had been made clear to Mr Mackenzie that his employment was going to be terminated, and he was given the option to resign. So, on our case, there are two relevant factors when one looks at the validity or otherwise, just taking it at headline level, of those two resignations letter. One, it had been made clear to him that his employment was going to be terminated in any event. Two, and one can see this from the extract that you were asked to read to yourself from Professor Ishmael's report this morning, it is relevant to look at my client's mental state at the very date those letters were written, and his known mental state to the respondent at that time. Because if I ask you to turn back to Professor Ismail's report, to the extract that you were asked to look at.
Look, just before we do that, can I just return to the resign or be dismissed? I've forgotten about Sheffield and Oxford Controls, if I ever knew it. This is very common battleground in employment tribunals, where there's no jurisdiction unless there's a dismissal. But resign or be dismissed, so he resigns, it may still be a dismissal rather than a resignation. We're talking about resignation from employment, not resignation from a board of directors. So resign or be dismissed, I resign, may nevertheless be a dismissal. For present purposes, so what? It's not suggested that your client's entire case should be struck out because you have no cause of action at all.
Well, we say that the resignation letters were ineffective. I mean, they've gained more prominence in the appeal than they did below. Certainly because my learned friend didn't press his case below on the basis that in any event my client had resigned. That was the second string argument that wasn't developed, but there was some discussion about it on the first day of the hearing. Our position, and we say this is a matter for trial, is that in circumstances of one, he was only resigning because he'd been told he was going to be dismissed, and two, the extreme mental position he was in at the date of resignation. And we've noted by Professor Ismail that the date of his admission to hospital was the same date as the letters. That first, no weight falls to be attached to those letters. And second, no weight was attached to them by the respondent because they regarded them as a trial rather than as a genuine resignation. So we say that they don't present an obstacle. And
Sorry, an obstacle to what?
well, as I understand the way that the defendant puts it now, it's on the basis that when one comes to assess damages for the wrongful dismissal, you've got to take it on the basis that the claimant had resigned anyway. And so that necessarily has a limiting effect on, in some way, on his entitlement to claim damages. We say, first, well, that wasn't really a point that was greatly developed below. And second, it doesn't stay in the way of what would normally be the recovery for wrongful dismissal in any event.
Is the effect of the line of authorities that one must necessarily ignore all the contents of such a resignation letter? And it's one thing to say that if you're told or it's made clear to you, you've got to resign or you're going to be sacked. That a letter saying, I resign, should be read in that context. What is a tribunal or a court meant to do with a letter which asserts ill health and asserts inability to carry out his work?
Well, my lord,
That's unnecessary for the resignation. And on your case, it's just untrue.
forgive me, my lord.
On your case, I understand it to be now to be said it's untrue and should therefore be ignored.
Sorry, which part of it, my lord? I'm afraid I don't follow.
Because of my ill health, I'm unable to continue to perform my employment duties, which he says twice.
Well, my lord, I don't say that at that time that was not true, and I accept that. The assessment, any assessment of the counterfactual has to take into account that he was at that time unfit and that his medical evidence indicated that he was likely to need a period of 6 months off work. So I certainly don't say, and if I've given the impression that to the contrary, I correct myself, don't say that one disregards his state of health as at the time of dismissal.
No, that wasn't what I was asking.
I've forgiven
It was whether one is obliged to disregard the fact that in a letter which you say is resigning rather than being sacked, he says unequivocally, I am unable to perform my duties. In such a letter, is the court or tribunal simply meant to disregard that? Or?
Well, I don't think there's anything. I don't think there's any particular weight to attach that from the letter. I mean, the medical facts and the position it was in, one must have regard to. But the fact that the day that he was hospitalised, in the circumstances he was in, he made a statement of his own understanding of his medical position and ability. I say there is, primarily I say there's no weight to be attached to that, or little weight to be attached to that, but in any event, that's a matter to be assessed at trial, to be attached to that. I mean, he was, in a position of acute mental health, to put it in its broader sense. I don't know if you'll forgive me for not wanting to get into the details of that in a public forum. So, at the date of hospitalisation with the mental health issues as they presented at that time, to say of any patient in that situation, well, that's what he said in a letter on that date, is profoundly unrealistic in my submission. And in any event, not a matter suitable for summary determination. And nor indeed did the judge below regard that as a plank of his decision.
I'm still puzzled as to why you're showing us this 1979 case on resign or be dismissed. It's both sides' case that Mr Mackenzie was dismissed by the board on the 1st or 2nd of August. Resignation from directorships, as we've observed, may be relevant to whether it was realistic to assume that he could resume his duties. But as to, quote, resignation from employment, the board said, we don't accept the resignation, we are dismissing you. So your client's cause of action is wrongful dismissal.
Yes, my lord.
So why does Sheffield and Oxford Controls help us? Sorry, I'm being a bit slow.
Well, I had only raised the resign or be dismissed principle, which I say, and I've handed the case up because it illustrates the point that I made on my feet last time. I had only made that point responsive to what I'd understood Mr Laddie to be suggesting, that the damages to which the claimant was entitled is in some way limited by the fact that he had chosen himself to resign. And all I'm saying is, you assess damages on the basis that he was dismissed, not on the basis that he'd chosen to resign in any event. My lord, I'm anxious not to repeat any of the points that I made in developing the appeal on the last occasion, so unless I can assist your lordships further, those are my submissions.
Right. John, I'll ask Lord Justice Popplewell, no, shake of the head.
Yeah, thank you.
Lord Justice Stuart-Smith, shake of the head. Thank you all very much. I'm grateful for your efforts both on this occasion and the last occasion. We will reserve judgment. Can I ask the juniors on each side to email to my clerk details which the Court of Appeal now requires, contact details of counsel, leading and junior, and 2 people at each solicitor's firm to be recipients of the draft judgment, which will be sent out in the usual way, with the embargo emphasised by the Master of the Rolls in Counsel General for Wales case. I'm sure all of you in court know all about this, but I'm required to say it, and we're required to ask for email addresses. I think we have everything we need. The quality of the argument given those involved was no surprise. Thank you all very much.
All rise.